Well, my submission is that your lordship has to go back to the origins of the 10th schedule. And first point under this head, brothers, is that the 10th schedule has two components, not only one. One is a prohibitory negative code. It's a negative code. So a negative code is what you should not do. Violate, whip, voluntary resignation, cohabiting with other people, etc. But there is also an affirmative, positive part of that code. And what the 10th schedule does is to strike a balance between the negative and the positive by a constitutional amendment. It is my respectful submission that it is vital for your lordships to give effect to both negative and positive in letter and spirit, because your lordship is actually implementing the constitution. And some of the arguments of the other side have bordered on suggesting that a mere, I'm using the word mere advisedly in comparison to a constitutional text, a mere symbols order will be competing with a constitutional text. That would be completely anathema to all known principles. What are these two codes, Balas? The negative code is that you, in a nutshell, I'm just saying, in a nutshell, I'm oversimplifying. You will not voluntarily give up membership to an A and you will not violate whips to one B. Just in a broad summary. What is the affirmative permissible activity? You are entitled to dissent only within that permissible zone. Otherwise, why enact the 10th schedule, Malas? Prior to 85, you didn't have the 10th schedule. You had Jungle-Raj, which you called Ayaram Gayaram sometimes, but then you can also justify that in the name of free speech, free action. What you did here was you allowed a zone of activity, permissible, affirmative, but you cannot say that I will go beyond that permissible and thereby violate indirectly the negative code also. What is that permissible activity? The affirmative code of conduct. One is a faction or a split till the 91st Amendment. They gave you an escape route, advisedly, consciously. That is gone. It was there. So well as the Constitution famous thought that along with a negative code of conduct, so as not to stifle you completely, we give you an escape route, exit route of faction or 1/3 or whatever it was called. Second, merger. Third, and this is actually the most important part of 10th schedule. Well, as elections, barring a few cases, in the days of 1960s, etc., there used to be a very strong, large number of independents. Independents have now dwindled. The statistics show, even then, in terms of 545 Lok Sabha, you had hardly 30, 40. But independents commanded a coordination. My father also got into Lok Sabha on an independent party listigate. So I know at that time, Mr. Nath Pai, so many people. But today, even then, party democracy was, everything was based on party. You got a ticket and you fought and you won because the party projected you as its candidate. That is now, much, much truer after the 60s, 70s onwards. Today, the number of independents compared to the 60s would be a fraction. So it's party-based democracy. You like it or not, it's not for anybody to question. We've chosen it, but there's nothing perfect. Some people say US is better, some people say European, but this is what we've chosen. And now, this third balance.
Third point is what? What is the point?
One is
split is permissible, merger
second is merger. Third now.
The third point.
Third comes with the light of what I said just now. The whole idea of the 10th schedule is resign and recontest. That's what is stopping you from doing. You enter the door through this door, and then you retain your ministership and seat while exiting through the other door. Sorry, not permissible. Resign, have the courage of your... Now, you are a very vocal freedom speaker. You have the courage of your conviction.
Which Justice Jeevan Reddy referred to in that extract.
I'll be dealing with some of
It
that.
was not in the context of the 10th schedule.
But I'll be dealing with that. Some judgments have referred to it. I'm going to suggest, because this is the core question my Lord Narasimha asked, my Lords asked earlier. What do we do when an overwhelming set of people want to express dissent? 9 tenths, let's say 9 out of 10 minutes. Let's take an extreme example. How do we balance and countervail these two competing balances? The 10th schedule says you can go thus far in balancing, not further. Whereas if you are so much for free speech, courage of your conviction, this is a rotten party, I can't say, resign and contest. Recontest, what is the problem? Then the fourth is the exemptions. Apart from merger, there's the exemption clause, condonation, whatever. All that is given there. Now, what we have to see is that if a constitutional amendment balances the prohibitory with the affirmative part, you cannot find an excuse to circumvent the prohibitory part by going beyond the 4 avenues of the affirmative part, now only 3. Action is gone. Now, let us take this further, because that's your Lordship's query. I'm sorry, there is a 5th one. I forgot. There's a 5th one. I'm now breaking it up. There is a 5th balancing on the affirmative side. You are so concerned about free speech. You are resigning is one. Or you absolutely hate where you are. You go to the Election Commission and start your para 15 proceeding that I am the real party. But you do that without indulging into the prohibitory part. That's keeping the sanctity of the 10th schedule. Now I'm addressing the core dilemma of my lords. Let me develop it, in a minute. That's also a statutory remedy, lower than constitutional. So the 5th is, now actually only 4, because that faction is gone, split is gone. So 4. The 4th would be file a complaint to the Election Commission, say, look, 9 of us are standing here, we are the party, recognize us. Till then, don't do any prohibitory activity. The Election Commission will or will not recognize you and is subject to challenge. What does this do, This maintains the sanctity of the 10th schedule and maintains the negative and the affirmative parts of the 10th schedule. What does my lord normally prefer? A option I give your lordships which reduces the other option to vanishing point? Or an option which harmonizes both? Elementary principles tell your lordship by 1,000 cases that your lordship prefers the harmonization approach. Elementary common sense shows that my learned friend stand reduces the 10th schedule to vanishing point. It is as good as a dead letter or a repeal. Which is better? The answer is self-evident. Now, here, just see, how this dead letter vanishing point arises. You don't resign with the courage of your convictions to fight another election. You don't go to the Election Commission till much later. Almost a month, just under a month after 21st, you went to Guwahati, 19th, you go to the Election Commission. 2 days before a month is ending. You don't seek condonation. What you do is, what I call a 3 steps novel procedure to annihilate the 10th schedule. It's a 3-step novel procedure. Step 1 of which is disable the speaker by giving him a mere notice. So the man can't touch you on the 10th schedule. Just see, my submission of harmonization versus vanishing point. Step 2 of this sinister 3-step novel procedure is to forward resolutions parallelly to the governor, who in turn makes it the basis of a trust vote direction. And the final step 3 is the act of being sworn in as Chief Minister.
Sorry?
The act of being sworn in as Chief Minister. With another party fully supporting, in whose lap you were in Guwahati. Now, I'm not on the, just kindly consider. You don't follow the affirmative part, which gives you play in the joints and leeway, flexibility. You don't resign. You don't merge. The most important, interesting point is you don't merge. Just see for a minute that B, 4B. If you are sitting in their lap and they are supporting you, at the last minute, instead of them becoming chief minister, they make you chief minister. What is the problem with merging? So, you say to hell with the 10th schedule, it gives me an escape route, I'll ignore it. I'll go to the 3 steps. And the language, without opening it, where his original political party merges with another political party, and he claims and any other members of the original political party have become members of such political party, or as the case may be, of a new political party formed by such merger. This is directly snooking a nose at the 10th schedule, which is a constitutional creation. It is, I'm sorry to use colloquial, it's actually saying, look, to hell with the 10th schedule, we have made this 3-step procedure. Why on earth could you not recontest, resign, merge, or the 4th one? Condonation, I'm not getting into, that's another one. Go to the Election Commission and file a complaint then. On 21st, instead of Surat and Guwahati, why did you not file the Election Commission? So this is the first answer. This is one of the best answer at least I can give to the direct question, but there is a consequential answer further ahead. I'm putting it against myself and trying to answer, because I put this question to myself and Lordship asked it yesterday. Now, a possible argument will be twofold. There is no argument, because how it works in actual law, a fact is not an argument against me. If the law is a prohibitive and a affirmative, then you jolly well follow it. That's the object of creating a constitution. But now I'm giving an answer against me, even though it doesn't arise in law. The answer is, what happens, Mr. Singhvi, if between me, that is they, applying to the EC and doing these things which Mr. Singhvi is advising them to do, the speaker disqualifies you? I'm putting it bluntly against myself. First answer is, so what? Why was the 10th schedule created? Is the speaker doing something unknown to law? But there's a better answer. If he disqualifies you, there is full judicial, this is on the basis wrongly. There is full judicial review. No, you can't, your lordships can't find a solution to everything which the Constituent Assembly, the Constituent amending people did not make. What is this answer? That what do? I will be disqualified. Well, jolly well you'll be disqualified, because the 1985 framers gave this power to the speaker. Is the possibility of an abuse ever the test of the power or its existence? Can it be? Otherwise, how will your lordship decide anything? Yes, that phrase comes from Rajanarayan versus Indira Gandhi. Possibility of abuse is not the test of power. Give that citation.
Hindustan judgment. Hindustan construction, some judgment is there.
Also Hindustan construction.
Abuse of power cannot be there.
Your lordship should judge everything. Oh, what will happen? What may happen? But that's not the question. Here, and your lordship is talking of lesser cases. Here, the constitution was amended to give this power. And the apprehension is, I will not go on 21st to speaker, to EC. I will go to Guwahati, because I'm scared of a disqualification. Now, let us look at the second. I'm giving a lot of extreme examples against myself. You have a full review possible. My review is much more truncated. It takes 1 year for me to get this hearing before your lordships. Your review is immediate on a wrongful decision against the speaker. And your lordship knows, Kyoto says, after a final decision of the speaker, you will get a stay of that. You can't get a stay while he's deciding. You can get it afterwards. Of the disqualification also. Only a quia tibet is stopped.
You're comparing that with what?
With the fact that, if you don't do this and stay and make the 10th schedule a dead letter and install a new government on the basis of ignoring the 10th schedule, that is much less reversible by sheer passage of a few days than your right to challenge. Today, what is the whole argument? It's a scrambled head, it's a fait accompli. Your lordships can't reverse it. It's 1 year down the line. That's the real argument today. That's the argument we are facing. Now let me give you another bizarre example against myself. These are not one of normal examples, whereas I don't know of except a very few number of cases where you have the courage of conviction to resign and recontest. That resignation is impeded. It happens. There are 2 or 3 judgments we have. But normally,